Well, you know those terms and conditions many of us agree to without even reading them? Disney is trying to use them to fend off a wrongful death lawsuit. A man in New York is suing the company after his wife suffered a deadly allergic reaction at a restaurant at Disney World. But Disney, for its part, is saying he cannot sue because he agreed to arbitrate any disputes with the company when he signed up for a free trial of Disney Plus in 2019. Joining me now is Amy Feldman. She's a lawyer and author. Amy, it's good to see you again. So first off, anyone listening to this might say, what on earth does Disney Plus have to do with this? A restaurant that was at Disney World. And what does it mean exactly to arbitrate a dispute?
Yeah, so that's a very good question, Ziegler. First of all, most people don't know what binding arbitration is or what the problem is when they sign up for those terms and conditions, which, as you said, most people don't even read. Binding arbitration means that if you have a dispute with the other party, you don't get a trial by jury. You don't get to speak before your peers about why they owe you money. Instead, you have to go with a neutral arbitrator, and it's binding. So if you don't like what the arbitrator has to say, you don't have the opportunity to appeal it.
And Amy, we should note that the plaintiff's lawyers say that Disney's claim is, quote, so outrageously unreasonable and unfair as to shock the judicial conscience. Meanwhile, Disney issued a statement saying, quote, we are deeply saddened by the family's loss and understand their grief, given that this restaurant is neither owned nor operated by Disney. We are merely defending ourselves against the plaintiff's attorney's attempt to include us in their lawsuit against the restaurant. It's a lot of back and forth, but Amy, all of us interact with products from big corporations every single day if we're on our phone, our computer. So if Disney's argument does hold up here, what does it mean for the average consumer?
It means they should be terrified, is what it means, right? Because a reasonable person would not think, because I've signed up for a trial subscription to Disney Plus, that I don't have the right to sue for an injury that happens on a Disney property. Think of all of the various multinational corporations that have tons of affiliates. Do you ever think when you sign up for a website for one product, which you haven't read the terms or conditions, that you lose the right to sue any other product that company has anything to do with in perpetuity? It's terrifying. Yeah. And it is, the lawyer is correct that it's a very surprising and, quite frankly, unconscionable view to say you never get the right to sue.
Yeah, I mean, to that end, I want to make sure we hit this. If these terms and conditions are viewed as binding contracts, right, the things that we sign or check every day, can regular people actually try to negotiate and get them changed?
You know, there have been a lot of arguments, sometimes against credit card companies, sometimes against other companies where they said, but I didn't read it, but I didn't understand, but I didn't know. And for the most part, these binding arbitration clauses have been upheld only in cases where within those terms of use, the company has not made it clear. There was a case where the company didn't make it clear or didn't clearly explain what is binding arbitration and what are you giving up that the company lost. But you do need to be very mindful of what else this is going to prevent you from doing. If you see something that says, and its affiliates, you have binding arbitration against this company and its affiliates, figure out who that is and then decide whether you really want to go on this website or if you're concerned about the rights you will lose.
Really good point to end on. Amy Feldman, always appreciate it. Thanks so much.
Thanks for watching. Stay updated about breaking news and top stories on the NBC News app or follow us on social media.